Hello, my name is Maria Strapolursi. I'm an associate at Orrick, Herrington Sutcliffe's Boston office in the corporate practice group. My practice focuses on working with tech companies from formation all the way through financings and eventually exit through a merger or acquisition. And I'm pleased to be here today presenting on how to choose the best legal form for your business and how to get that started up on behalf of the Los Angeles County Bar Association. So let's get right into things. So the agenda for today, we're going to first talk about the different types of businesses that exist for you to choose from, some practical considerations when you're deciding what type of entity you want to form. Then we're going to talk about the key elements of each of those forms, and then talk about how you actually go about getting set up. And finally, we'll provide some resources that will be hopefully helpful as you begin to form your company. So first, the types of businesses. You've probably heard of a bunch of these before. There's sole proprietorship. That's generally a single individually owned business. Very easy to set up and operate. A limited liability company, which is a very flexible entity, pretty recent kind of creature. Partnerships, there's two different kinds, a general partnership and a limited partnership. We'll talk about the difference between those. And then a corporation, also a few different types of corporations, the C corporation, the S corporation, and a public benefit corporation. We'll talk about those differences as well. All right, so practical issues to consider. Obviously, a lot of different factors to think about when you're deciding what type of entity you want to use. It depends kind of on how many people are going to be participating in the operations, in the running of the business, you know, what types of services you're going to be providing, what types of products you're going to be selling, and then obviously tax as well. So we're going to be talking first about the costs of formation, then a little bit about the kind of personal liability, then about taxation, whether it's a pass-through entity or whether there's going to be taxation on two different levels, and then management, so how actions are going to be taken depending on the form that you choose. All right, so costs of formation. There are filings that need to be made when you're setting up most of these entities. For the sole proprietorship, as you can see, there are no documents that need to be filed to be set up. You basically just get started. Whereas for each of the others, there are documents that you need to file with the Secretary of State of the state where you're planning to form. This presentation focuses on Delaware, which is probably the most common jurisdiction for companies to form in. We'll talk a little bit later about why that is. But as you can see, costs can range from about $90 all the way up into $200. At least in Delaware, it can be more or less expensive in other states. Something just to remember is that you should consider turnaround time. So Delaware can get some filings back to you within 2 hours, and then it can also take a few weeks for some other filings. So just something to consider. Also, some states will allow you to use DocuSign, which is an electronic signature, or a conformed signatures, while other states will not. So you should check the Secretary of State's website for your respective jurisdiction. All right, the next thing to think about is kind of the risk of personal liability. So you want to think about kind of how much exposure you're going to have, and you may also, of course, want to purchase insurance, but the type of entity that you choose can also help shield you from personal liability. So generally, if formalities are observed with a limited liability company, a limited partnership, or a corporation, the owners of the company will be shielded from personal liability. That means that creditors of the business would not be able to go after the personal assets of the owners of the company, and they would also not be responsible for any business debts or claims arising out of any lawsuits. Whereas for sole proprietorships and for general partnerships, they can leave the owner exposed to personal liability for the company's debts. It is important, though, to note that it is possible, even with the limited liability company, the corporation, or the limited partnership, if corporate formalities are not observed, those owners can still be liable. A court can do what we call pierce the corporate veil, which means that they kind of look through the entity and find the individual liable. So some of the ways to avoid this are to observe corporate formalities like holding regular shareholder or board of director meetings, maintaining minutes, keeping bank accounts separate for the individual owners and the company, avoiding commingling of funds, things like that. All right, so now we're going to talk about taxation. So there's a concept of pass-through taxation, right, where any income or losses flowing from the business will actually pass directly through to the owners or the partners or the shareholders, depending on the type of entity, and they pay tax directly when they file their personal taxes. So some pass-through entities are the sole proprietorship, limited liability companies, although there is some flexibility to structure these to be taxed as like a corporation without the pass-through. General and limited partnerships are both pass-through tax entities, and the S corporation. All right, so in Delaware, just something to note, an S corporation's income will pass directly through to the shareholders, actually in proportion to their ownership of the company. So this is in contrast to the C corporation, which is taxed on two levels. They're taxed at the entity level and at the shareholder level. So the corporation's profits after deductions for certain expenses are going to be taxed at the corporation level, and then separately shareholders will be taxed on any dividends that they receive from the profits made by the company. And then in addition to that, employees of the company, of course, will be taxed on their salaries, on their personal income. All right, and then kind of the last consideration we're going to talk about is how the company is managed, or how action is going to be taken. So sole proprietorships are owned and operated by a single person by definition, so that's pretty simple. There aren't really any corporate formalities that need to be observed. For all of the other different types of entity, there are governing documents. So for example, for an LLC, they have an operating agreement. A partnership would have a partnership agreement. For a corporation, they have bylaws and a certificate of incorporation or a charter that kind of govern how the companies should be run. In a corporation, you would typically have a board of directors, and they would have meetings where they could make decisions, usually by majority approval. You could also have actions being taken by written consent, unanimous written consent of the board. And then an LLC, and we'll talk a little bit more about this, can be run by the members, or it can be run by a board of managers, which operates similarly to a board of directors in a corporation. All right, so now we're going to talk a little bit more about each of these different types of entities, go into a little bit more detail, starting with the sole proprietorship. So as we said, this is one of those situations where the owner and the business are one and the same. There's no legal distinction. So there aren't any registration requirements unless you're not planning on using your own name to operate the business. In that case, you would need to register a DBA, or doing business as, but otherwise no filings that need to be made. As we said, this is best suited for a single owner business where they don't have any real tax concerns. It's going to be flowed through, passed through taxation, and also where there's going to be kind of limited potential liability. Of course, sole proprietors should consider buying insurance, particularly because they're not shielded by the corporate entity from liability. So some of the pros are that the owner will have sole control over the business, and it's simple and inexpensive to create and operate because there's nothing that needs to be filed, no corporate formalities that need to be observed. Some of the cons are that the owner has personal liability for business debts and lawsuits, and that creditors can go after their personal assets. As I said, it's a pass-through tax entity. So at income time, the sole proprietor will just report the business income and losses on their individual tax return, and the business itself is not going to be taxed. So something else to keep in mind is that the owner of a sole proprietorship is going to be personally responsible for what they call a self-employment tax. Essentially, they're going to be paying for their own Social Security and Medicare taxes. All right, the next type of entity is a limited liability company. They can have one or more members, which are owners, and the limited liability company can be managed by its members, or they can have a separate management team, a board of managers that manages the company. This is best suited for a single, individually owned company or a company with multiple owners, where they're seeking pass-through taxation and limited liability. So the pros are that liability is generally limited to the extent of the owner's investment in the company. Profits and losses, however, can be allocated however you want, as presented in the operating agreement. It doesn't have to be based on the contribution to the company. And any person can become a member. It could be, another LLC, a corporation, a foreign individual. So a lot of flexibility with the LLC. There are some cons, right? So they can be, owners can be held personally liable for the debts of the LLC, including when they make a personal guarantee, and then they can also be held liable if they act negligently or breach their fiduciary duties. Additionally, some LLCs have to comply with securities laws, which can get a little bit more complicated. Also, any member of the LLC can legally bind the company to an agreement with a third party if that third party is not aware that member does not have that authority. So you have to be a little bit careful with how you're presenting agency. Also, LLCs are less likely to get funding from VCs, from venture capitalists, as compared with the C corporation. So something to think about if you're planning on getting institutional funding. These are newer entities, like I said. So in Delaware, LLCs only came into existence in 1991. So there's less established case law surrounding LLCs, which makes them a little less predictable and thus a little less appealing to VCs. And then just kind of the last consideration is that many states, including New York, have a publishing requirement that can add to the costs of forming the company. So basically, you would be required to give notice to the public in either a newspaper or some other form of publishing that the company has been formed. All right, so tax considerations. Limited liability is a pass-through entity, although they do have the option to be taxed as a corporation. And the company is also responsible for distributing K-1s to each of its members. The K-1 is just a report of each of the members' shares of the earnings, losses, deductions, and credits. And it's just kind of similar to a 1099. All right, for general partnerships, the first of the types of partnerships that we're going to talk about. This is best for business with multiple owners, all of whom are planning on being involved in the management and the operation of the company. It has pass-through taxation, and since there is not protection, a shield against liability, it's best for businesses where the potential product or services liability is minimal. So some of the pros: partners can generally claim losses and business expenses as personal tax deductions. And again, this is one of the more simple types of entities to create and move forward in managing. Fewer corporate formalities, certainly, than the corporation. All right, some of the cons: partners can be personally liable for business debts and lawsuits, including actions taken by other partners. So each individual partner can be sued for the full amount of the business debt, but then they can seek contribution from their co-partners. Additionally, creditors can go after the personal assets of the partners. And then, similar to in the LLC, any partner can bind the business to a contract with a third party if the third party is not aware that partner does not have the authority to do so. Additionally, and this is kind of one of the biggest cons of the general partnership, is that in certain states, if a partner dies or withdraws from the partnership, the partnership can actually automatically be dissolved. So you definitely have to be careful about that. For some tax considerations, it's a pass-through tax entity. As we've discussed, income deductions, credits go directly through to the partners, generally as set forth in the partnership agreement, which is one of the governing documents of the partnerships. And then, similar to the LLC, the partnership is responsible for providing K-1s to each of its partners. All right, limited partners and limited partnerships. So again, this is good for a business with multiple owners, but in this case, there's going to be one general partner who is involved in the management and the day-to-day operation of the company, and then at least one limited partner who is going to be more of a passive investor. And they have limited control over the business operations and management. All right, so some of the pros: the partners can claim losses and business expenses on their personal tax deduction. It's a pass-through tax entity. And the liability of the limited partner can be limited to the extent of the partner's investment. That's the limited partner. But some cons are that the general partners are personally liable for the business debts and lawsuits, including actions of their partners. And creditors can go after the personal assets of the general partners. So oftentimes LLCs will be structured with, partnerships will be structured with an LLC or a corporation actually acting in the general partner role, so that they have that extra level of liability protection. And then, as I said before, for general partners, same thing here. The partnership can be dissolved automatically when one of the partners dies or withdraws from the partnership. And again, it's a pass-through entity. Income deductions and credits pass through directly to the partners in the proportions that are set forth in the partnership agreement. And then the partnership is responsible for issuing K-1s to all of its partners. So that can be an administrative burden. All right, C corporations. So C corporations are owned by, they call them stockholders in Delaware, and in most other states they will call them shareholders. These are best suited for single and multiple owner businesses where they're looking to ensure limited liability. Some of the pros are that that limited liability for business debts and lawsuits, although, if you don't follow the pretty stringent corporate formalities of corporations, a court can pierce the corporate veil and find, management and owners of the company to be personally liable. Lawsuits are brought against the corporation rather than the owners or management. And it's also the best option where a company anticipates that they're going to be fundraising from VCs. So Delaware is the typical preferred jurisdiction for incorporating companies. There are a few reasons. One is that Delaware has a special court called the Court of Chancery, which has judges that specialize in corporate cases. The dockets aren't getting crowded with non-corporate cases. The judges have, specialize in these types of cases, and they also make decisions without a jury. Additionally, Delaware's tax system gives businesses several ways to legally minimize their tax bills. So companies that are incorporated in Delaware but do business in other states don't actually have to pay state corporate income tax to Delaware. And Delaware also doesn't tax on profits, on royalties, trademarks, or copyrights. So Delaware has made themselves a very appealing place for incorporation. All right, so some of the cons of the corporation are that they are expensive and can be difficult to create. There's a lot more paperwork, a lot more corporate formalities or administrative tasks that need to be observed. This can be burdensome, so basically having frequent stockholder meetings, frequent board of directors meetings, making sure you're documenting all of that, keeping track of the minutes. You need to issue stock. You also need to comply with securities laws because stock is a type of security. And C corporations are not pass-through tax entities. As I think I mentioned before, they are taxed on two different levels. So the company is taxed on the profits after deducting certain business expenses, and then the shareholders are going to be taxed on dividends that they receive from those profits. And then again, any owners of the company who are employees, maybe they're acting as a CEO or president, and if they have a salary, they would also be taxed individually on the income from those positions. All right, S corporation. So these are generally for closely held for-profit companies, best suited for family business because there are restrictions on how many stockholders are permitted for an S corporation. But unlike the C corporation, the S corporation has pass-through taxation. So basically it has all of the advantages of the C corporation with the limited liability, but it has pass-through taxation. So S corporations it can be difficult to maintain that status. You can kind of blow S Corp's status and become just a regular C Corp. You would want to discuss with your tax advisor whether this kind of entity makes sense for you. But there are some cons because obviously there are very stringent requirements to remain an S Corp. So the shareholders can only be individuals. And certain trusts, estates, and then certain exemptions for some organizations like nonprofits. But typically they can't be, shareholders cannot be partners or partnerships or corporations. The shareholders have to all be U.S. citizens or U.S. residents. The business actually can't have more than 100 shareholders, which sounds like a lot, but they can certainly add up quickly, especially if you're issuing options to employees. They can also only have one class of stock. And profits and losses can only be allocated in proportion to each stockholder's interest in the business. And then, of course, all shareholders must consent to the S Corp election. So a lot of restrictions. They can be, because they must consent to the election and consent to removal of the election, they can be difficult to create and then also to dissolve. Same administrative duties as the C corporation, so keeping track of minutes, issuing stock, making sure officers are properly elected, all of that, and you still have to comply with securities laws. All right. So the biggest kind of consideration for the S corporation is the tax consideration. It is a pass-through tax entity. Stockholders must allocate profits according to the percentage of their ownership. This is different with LLCs and partnerships. You might remember us discussing this can be it doesn't have to correspond with their ownership percentage. It can be however is provided for in the operating agreement of the company, but for S corporations it is going to be tied to their ownership of the business. Additionally, the corporation will have to issue K-1s to each of its shareholders. And as I said, you should really speak with an accountant if you're thinking that this might be the type of entity that you're interested in. And then finally, there is kind of a newest type of entity, which is the public benefit corporation. In some states, it's called just a benefit corporation. These are for-profit companies, but they also are balancing maximizing value to shareholders with a legally binding commitment to a social or environmental cause. So in contrast with other for-profit entities, the ones we've just talked about, which by law have to focus on increasing the returns to their owners, a public benefit corporation is actually required to consider other stakeholders in addition to just its shareholders. So those might be employees, customers, the environment, or certain other communities. And the public benefit corporation's charter or certificate of incorporation, the governing document that is filed with the Secretary of State, actually is required to specifically identify the positive effect or reduction of a negative effect that is going to flow to the stakeholders that is artistic, charitable, cultural, economic, educational, environmental, literary, medical, religious, scientific, or technological in character. So obviously can span a wide range of missions. A few examples of public benefit corporations that you may have heard of are Patagonia, Kickstarter, and Method. And a public benefit corporation should not be confused with a B Corp. This is something separate. A B Corp is actually just a certification from a nonprofit organization called B Lab that basically indicates that a company holds itself to a high standard of social and environmental performance. That is not actually a type of entity, whereas the public benefit corporation is recognized by, I think, almost all of the states at this point as a type of entity, whereas the B Corp is just a certification. All right, so now we're going to talk about actually getting a company set up and some of the considerations after you've chosen your legal form, what the next steps are. So again, after you choose the form from one of the ones that we've discussed, you'll choose a legal name, you'll file the organizational documents, obtain a federal employment identification number, qualify to do business as a foreign entity in any other jurisdictions where you're operating, register a fictitious business name or DBA if that's needed, obtain local tax registration certificate, and obtain any required permits and licenses. All right, so as we discussed, the first step is to consider all of the things I just mentioned about the sole proprietorship, limited liability company, partnership, or corporation, which one is going to be best for you. That's kind of the threshold question. Then you should choose a name. So you can check to see, definitely generally on the corporate webpage of the state in which you're planning on forming, whether your name is available. You can do a search of entities that are incorporated or formed in that state to make sure your preferred name is available. And then when you file your organizational documents with the Secretary of State, that is also registering your name at the same time. That'll be included in the organizational documents. There are specific naming requirements that apply to some of the entities. For a sole proprietorship, you would typically use your birth name. If you're not planning on using your birth name, then you would use a DBA, a doing business as, and that you would need to register with your local county. For a limited liability company, you need to use certain words at the end of your business name. So, words or abbreviations, and that's the same for the limited partnership and the corporation as well. No specific naming requirements for general partnerships. All right, so the next step is going to be preparing and filing your organizational documents. For a sole proprietorship, there are no filing requirements. One of the reasons why they're obviously appealing, they're very cheap to form. For a limited liability company, and again, this is all specific to Delaware, so you should absolutely check the corporate webpage of the state in which you're planning on forming. But at least in Delaware, for limited liability companies, you would be filing the certificate of formation with the Delaware Secretary of State. And then after that's filed, the members would enter into an operating agreement or an LLC agreement, which kind of governs the operations of the company, the relationship between the members and the managers, if there are any managers. This is not publicly filed, but this is important to have a governing document that guides the operation of the business, the management of the business. For general partnerships, you would file a statement of partnership existence, and then again, not filed, but similar to the operating agreement for an LLC, the partners would prepare a partnership agreement which summarizes the obligations of the partners and controls the operation of the business. It's important to know that there are default rules in place called each state have adopted their own version of the Revised Uniform Partnership Act. And this act establishes standard rights and responsibilities of each partner. So in the absence of the adoption by the partnership of a partnership agreement, these default rules will apply. All right, and then for a limited liability partnership, the partners will file a statement of qualification with the Delaware Secretary of State, and then they'll prepare a limited liability partnership agreement, same situation as the partnership agreement, and again, that the RUPA, or the Revised Uniform Partnership Act, will apply in the absence of this agreement. All right, and then for C Corps, S Corps, and public benefit corporations, in Delaware, you'll be filing a certificate of incorporation. In California, it's called Articles of Incorporation. And the incorporated, the person who's forming the company, will also adopt the bylaws, which are the governing document for a corporation, and then they'll appoint generally the initial directors of the company. Bylaws are not publicly filed, and then the idea would be for the board of directors to hold an initial organizational meeting where they would elect officers, issue any initial stock to the founders, authorize the company to obtain a federal employment identification number, open any bank accounts, enter into indemnification agreements, and that kind of will help set the course of how the company is going to be run. All right, so next step is, after the formation of the company, is obtaining a FEIN, or Federal Employment Identification Number, which is, you may have, it's similar to a Social Security number for an individual. It identifies the business. It's used on tax filings. A lot of important business documents will require it. And they're required for essentially all businesses, even if they don't have employees. To obtain it, you can either file the form SS4 by mail, fax, or on the phone, or you can apply online with the IRS to obtain the number. All right, so if you're operating the business outside of the state in which you've formed, it's likely that you're going to need to register to do business in those other jurisdictions. So some of the things to consider are whether you have a physical presence in that state, like an office space or retail store, if there are any employees of your company working in that state, if you're paying state payroll taxes, how often you're having kind of face-to-face contact with customers there, and whether you've applied for any licenses or permits in that state, and whether a substantial chunk of your revenue is coming from that state. So the ramifications of not registering your company in states where you're operating can be pretty severe. You can face fines and interest for the time that you were conducting business in that state and were not qualified. You would also, of course, be on the hook for any filing fees that you should have paid to qualify. You would have to pay back taxes for the time you were doing business without being qualified. And then until you're actually qualified in the state, you would not be able to file a lawsuit there. Lawsuits could be filed against you, but you could not file a lawsuit in that state until you were registered. All right. So next thing to consider is whether you're going to need a fictitious business name. So let's say you are formed in Delaware, but you're operating in Texas, and there is another company with the same name as yours in Texas. Even though it was available in Delaware, it might not be available in another state in which you're operating. So in that case, you would need to get a forced fictitious name that would be registered locally. And this is the name that you're using in the operation of your company. So this is how you're presenting publicly. Still on the documents that the legal documents that you're signing, any contracts, you would be using the legal name that's on your formation documents. But this is how you're generally presenting to the public so that there isn't confusion between the two different entities with similar names. You can also choose to be using a different name than your legal name, and that's the difference between a forced fictitious name and what's called a DBA, or doing business as. It's just essentially the elective version, and that both of those will get recorded in the local registrar's office. All right, so again, this next slide just talks about for sole proprietorship or general partnership, you're not required to register any business name if you're just using the names of the partners or the name of the sole owner of the sole proprietorship. Otherwise, you would want to record a doing business as name, a DBA. And then again, the same thing for LLCs, for limited partnerships or corporations. If you're going to be presenting a different name to the public than what's in your formation documents, you'll need to get that registered. All right, next step is to obtain a local tax registration certificate, also known as a business license. And most cities do require this, including LA. And so you'll need to register with the city's tax collector. And this is regardless of the business type. All right, so now we're going to run through an example of a startup company. This one is founded by John and Jenna, who are the owners of the business that produce widgets. So first, they have to choose a legal form. So they've decided that they want to incorporate as a C Corp in Delaware because they anticipate that they're going to be raising money from institutional investors, and they also want to protect themselves from liability. John and Jenna choose the name Widgets Are Us, Inc. for their company. They have to have that corporate identifier at the end. And since they decided to incorporate in Delaware, they file a certificate of incorporation with the Delaware Secretary of State. John acts as the incorporator, so he's the one that signs the original certificate of incorporation and files it, and he adopts the bylaws, and he also appoints himself and Jenna as the members of the board of directors. All right, so after they get the evidence back from Delaware that their filing has been accepted, they will obtain a FEIN, and they do this by the IRS's website. I should also mention before they do this, they have their first board meeting where Jenna is elected as president, John is elected as secretary. They make their initial common stock issuances to themselves, and they authorize the company to open a bank account and to actually obtain this FEIN. All right, and since John and Jenna are incorporated in Delaware, but they're planning on doing business in California, opening a storefront, maybe opening a small factory there, they need to be registered to operate the business in California. So they file what's called a statement and designation by foreign association with the California Secretary of State, which can be done online. And then unfortunately, when they go to do this, they find that there is actually another company in California called Widgets Are Us Corp. Ours is Widgets Are Us Inc. But because it's substantially similar to that other existing California entity, it could cause confusion to customers in California, so they're going to have to choose another name. So they'll need to file a fictitious business name statement and register. They choose the fictitious name Wowza Widgets with the Los Angeles County Registrar Recorder and County Clerk. All right, next step is going to be getting that local tax registration certificate. Again, all companies doing business in LA need to obtain the business tax registration certificate, so and that can be done again online. And then since John and Jenna plan to sell goods and products that are taxable, they'll also need to register with the State Board of Equalization to receive a seller's permit. All right, so that wraps up our presentation. I hope that this has been helpful in evaluating which type of entity is best for your business idea and kind of the steps that you need to take to form the business. We do have a few resources here for you, online resources. The IRS webpage is very helpful. The Delaware Corporate Division, California Business Portal, a guide from NOLO on kind of small business considerations. And then, of course, you should always feel free to reach out to an attorney to assist you with any questions you have. So it's been a pleasure presenting for you all. Thank you for having me.